Dear students, now we move to the second part of the session. Let us differentiate between the citizen and alien. We shall understand the constitutional provisions given from Article 5 to 11, and we will try and understand Citizenship Act 1955. All the people of India can be classified into citizens and aliens. Aliens can be further subclassified into friendly aliens, enemy aliens. Who are the citizens? The members of the state. It's a kind of membership of state. All the citizens express their faithfulness to the state, allegiance to the state. All the citizens enjoy civil and political rights. Not only this, citizens enjoy so many other rights. This is not exhaustive. Aliens are members of other state. They do not belong to this state, or sometimes stateless people. They don't have any state. They do not enjoy all the political and civil rights what citizens enjoy. And there is also again further classification. Friendly aliens enjoy more rights than enemy aliens. Who are friendly aliens? Who are enemy aliens? Enemy aliens are the people from countries which are at war with India. Let's say, for example, China is at war with India. Now, we are not at war with China. Let us say, assume that China is at war with India. All the people of China who are residing here in India become enemy aliens. Who are friendly aliens? All the people from countries with whom we have cordial relations. We have cordial relations with almost all the countries. And friendly aliens enjoy more rights when compared to enemy aliens. That's the difference. Rights and privileges denied to aliens. What are the rights which are given to citizens and which are denied to aliens? Fundamental rights provided in Article 15, 16, 19, 29 and 30. They are not given to aliens. Right to vote, right to contest in any of the elections, either central, state or panchayat elections, they were not given any right. Holding public offices like president, vice president, judges, governors, attorney general, advocate general, and many other positions. All these are not granted to aliens. You'll see the example. I've just quoted the Constitution, Article 15, 16, other articles. Article 14, right to equality. Equality before law, the state shall not deny to any person. That means Article 14 is for all, for aliens and for citizenship. This right is given to citizens as well as aliens. Look at Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. The state shall not discriminate against any citizen. Article 16 is only for citizens. It's not for aliens. Look at the difference. I wanted you to observe the difference. Equality before law or right to equality. Article 14 applies for all. Even aliens are entitled for this. Aliens are not entitled for this. Only citizens are entitled for Article 15. Look at Article 19. Protection of certain rights regarding freedom of speech, etc. All citizens. Article 19 applies only to citizens. Article 20. Protection in respect of conviction for offences, no person shall. This applies to citizens as well as aliens. I just wanted to observe, that's the reason I have quoted these articles from the Constitution. Now we come to the very important segment, constitutional provisions, part 2 of the Constitution from Article 5 to 11 explains who is considered a citizen, who is not considered a citizen, what are the procedure to acquire citizenship, what are the powers which are vested in the Parliament regarding citizenship. All these are explained from Article 5 to Article 11. Article 5. Citizenship at the commencement of the Constitution. When the Constitution was commenced, who are all considered as citizens? That is to be noted. Article 5 notes that at the commencement of this Constitution, every person who has his domicile in the territory of India. That means a person residing permanently in India, or the person who resides with an intention to settle down permanently in India. And that means this has to be qualified, residing permanently in India, or with that intention. That's the meaning of domicile in the territory of India. One of these, see, and or either A or B or C to be fulfilled to be a citizen at the commencement of the Constitution. Who was born in the territory of India, see, should be residing, and if that person was born in India, that means he is granted citizenship at the commencement of the Constitution. Clause B is residing, domicile in the territory of India, and either of whose parents was born in the territory of India. Suppose if he was not born, at least either of whose parents was born, either his or her mother, his or her father should have born in India to get the citizenship at the commencement of the Constitution. Next, clause C. He should be or she should have his or her domicile in the territory of India, and who has been ordinarily resident in the territory of India for not less than 5 years, immediately preceding such commencement shall be a citizen of India. That means if these two criteria are not fulfilled, at least if that person has been residing for 5 years, ordinarily resident for at least 5 years, then that person is considered a citizen at the commencement of the Constitution. It's just to put it in simpler words, suppose a Constitution is getting commenced now. That person, all the people who resided or who have been residing in India with an intention to reside permanently, and they have been residing for the last 5 years, they were all given the citizenship. They were all considered citizens according to Article 5 of the Constitution. Right? Before we understand Article 6, 7, 8 and 9, let us understand some ideas which we come across in those articles. Generally, we find the word undivided India as per 1935 Act in so many places. We do come across in these upcoming articles. What is undivided India consists of as per Article 1935? Undivided India includes Pakistan, Bangladesh and the present India. Earlier it was known as West Pakistan. The present Pakistan was known as West Pakistan. Bangladesh was known as East Pakistan. And we have so many princely states, other states getting merged into our nation, right? Burma or Myanmar was not part of undivided India as per 1935 Act. Afghanistan was not part of undivided India as per 1935 Act. First wave of migration. It's a migration which occurred in the month of March 1947. Second wave of migration. It's a migration which occurred after 19th July 1948. What is the importance of March 1947? What is the importance of 19th July 1948? March 1947. There were communal violences in the month of December 1946 and then January, February, March of 1947, because of which people were migrating, moving. Primarily Hindu and Sikh people were migrating from West Pakistan to India. There were also movements of Muslims from India to West Pakistan. This movement, this migration is considered as first wave of migration in the independent history. 19th July 1948. It was the day when permit system was introduced in the independent India. What is this permit system? See, if we understand the migration, in the first wave of migration, primarily Hindus and Sikhs moved from West Pakistan to India in 1947, around months of March, April, February. Then, after the independence, there were Muslims who moved, or before independence, probably in the first wave of migration, and after the independence also, Muslims moving from India to West Pakistan. And it was all, the situation was chaos. Sometimes they were able to sell their property, sometimes they left the property in as is where is condition and they moved. These properties, these places were accommodated to the people who came from West Pakistan. You get the point? There were people moving from here, India, and there were properties left abandoned. These properties were accommodated to the people who migrated from Pakistan. A lot of chaos, a lot of communal violence. All these systems, they were getting subsided, things were getting under control, and suddenly, for reasons unknown, there were people coming back from Pakistan. These people, there were a lot of people coming from Pakistan, that is, earlier it was called West Pakistan, in 1948. So at that time, Jawaharlal Nehru, Patel, they have decided, let's have some kind of control over the movement of people. So they decided and introduced permit system. That means whoever want to move from West Pakistan to India, they need to take permission from the commissioners located in Lahore and Karachi. There were Indian High Commissions located in Karachi and Lahore, and they need to get certification, permit from them that they want to reside permanently in India, and if these commissioners are satisfied, they issue a permit. With that permit only, the people were able to move to India since 19th July 1948, right? And remember, permit system, the persons immigrating from East Pakistan did not require permits. Then East Pakistan, the present Bangladesh, did not require the permit system. It's important probably for your prelims. Now we move to Article 6. Article 6, rights of citizenship of certain persons who have migrated to India from Pakistan. This article treats all the people who migrated from Pakistan to India into two groups. the people who migrated before the introduction of permit system and the people who migrated after the introduction of permit system. The permit system was introduced on 19th July 1948. Now let's talk about the first group of people who migrated to India before the introduction of permit system. The first group should fulfill two conditions. Condition number one, the person who is applying or his or her parents, either of the parents or either of the grandparents, at least one of them should have born in India. Condition number one, he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935. Next, condition number two, they should have been ordinarily resident in the territory of India since the date of migration. The moment they migrated, they should have been resided ordinarily in India itself. If these two criteria are fulfilled, first group should be granted citizenship. Now we'll talk about second group. Second group, the people who migrated to India from Pakistan after the introduction of permit system. It's the same. He, either of his parents or any of his grandparents, was born in India as defined in the Government of India Act. Condition number one to be fulfilled. Next, condition two, he has been registered as a citizen of India by an office appointed in that behalf by the government of the Dominion of India on an application made by him, therefore, to such officer before the commencement of this constitution. That means properly they should have applied for it and granted the permit system, granted the approval through proper channel. If this condition is fulfilled, even the second group would be awarded citizenship. And now for both these groups, one thing applies. That is, before applying for citizenship registration, they should have been residents in the territory of India at least 6 months. It is applicable to Group 1 and Group 2, the people who migrated before introduction of permit system and for the people who migrated after the introduction of permit system. Article 7. Rights of citizenship of certain migrants to Pakistan. This article talks about two elements. Point 1. All the people who migrated to Pakistan from 1st March 1947. That is, we talked about first wave of migration. All those people shall not be considered as citizens of India. Clear? People who moved to Pakistan from 1st March 1947, not citizens. And all the people who remigrated from Pakistan to India shall be considered as citizens provided they enter through the means approved by the Government of India, and they shall be considered as people who have migrated to the territory of India after 19th day of July 1948. Article 8 of the Constitution. Rights of citizenship of certain persons of Indian origin residing outside India. Who are those certain persons of Indian origin? As per this article, it is a person or either of his parents or grandparents if he or she was born in the undivided India as enacted in the Government of India Act 1935. They are considered as those set of people, the persons of Indian origin, as per this article. Just for this article, if they register as citizens of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him. What does it mean? Suppose the person who is living in a particular country, if he or she registers himself or herself to acquire the citizenship of India or retain that citizenship, either at the commencement of the Constitution or afterwards, that person will be given the Indian citizenship and his or her citizenship is retained. Article 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. Suppose a person in search of greener pastures, better economic development, or a better life in any of the chosen field prefers to reside in any of the foreign countries, let's say for example the United States of America. And the moment that person acquires the citizenship of that country, either it's United States of America or Canada or whatever may be the country, the moment that person acquires voluntarily the citizenship of that country, we shall not treat him as citizens of India. It's very simple. Article 10. Continuance of the rights of citizenship. Here we need to look at two aspects. The first aspect is that all the powers are given to the individuals, all the rules and regulations made as far as citizenship is concerned shall be continued. However, it gives power to the Parliament to make any law that may be required to govern the citizenship. It is subject to the provisions of any law that may be made by Parliament continue to be such citizens. That means if a law is made by the Parliament, it shall govern the existing rules and regulations concerning the citizenship. Article 11. This article is to be remembered. It's very important article as far as citizenship is concerned. Parliament to regulate the right of citizenship by law. This article empowers Parliament to make laws with regard to acquisition and termination of citizenship. Our constitutional framers left the choice to the Parliament with regard to the acquisition and termination after the commencement of the Constitution. They also kept in mind the changing times or the times which will be changed after some time. Hence, they have vested enormous powers in the Parliament with regard to acquisition and termination of citizenship, and also all the other matters relating to citizenship. Says Parliament to regulate the right of citizenship by law. It's very, very important. The Citizenship Act 1955 was legislated by the Parliament based on the powers it received from the Constitution through Article 11. Now, let us understand the Citizenship Act 1955. This act, as we have seen, derives a power from Article 11. This act delineates the acquisition of citizenship in 5 ways. A person can acquire citizenship of India either by birth or by descent or by registration or by naturalization or by incorporation of territory. Let's understand one by one. Citizenship by birth. If we have seen part A of the session, we understand what jus soli means. It's nothing but acquisition of citizenship based on the birth, based on the place of birth. We have followed, or we have been following, the principle of jus soli. However, we followed that principle, right of soil or right based on a place of birth, or the principle of jus soli is being followed in India. We followed unrestricted jus soli till 1st July 1987. What does it mean? That means the moment the child is born on the soil of India, that child is given the citizenship of India. We don't see the nationality of parents. We used to only provide based on the birth of the child on the soil of India. However, through the Constitutional Amendment Act 1986 made to this Principal Act, there was a change which was brought with effect from 1st July 1987. What was the change? Either of parents should be an Indian. Either father or mother should be an Indian citizen in order to grant the citizenship to that child. That means lex soli has come into the picture. That means some kind of restriction is imposed to jus soli, the principle which we have been following, or which we followed till 1st July 1987. It was followed till 3rd December 2004. Through Constitutional Amendment Act 2003, there were 2 changes which were brought. That is, condition 1, one of those conditions to be fulfilled. Either both the parents should be citizens of India, or one parent should be the citizen of India and the other should not be an illegal migrant. We have seen who is a migrant. One person should be a parent, the other person should not be an illegal migrant. That's what was the amendment made through Constitutional Amendment Act 2003. This is how citizenship is acquired through birth in India. Right? Principle of jus soli followed unrestricted way till 1st July 1987. After that, through some restrictions, we still follow the principle of jus soli. We do follow the principle of jus sanguinis. See, from the commencement of the Constitution till 10th December 1992, a person born outside India, if the father is an Indian citizen, that child used to get the citizenship of India. There was again an amendment carried out in 1992 with effect from 10th December. They have changed the wordings. Instead of father, they have placed the word either of parents. If either father or mother is an Indian citizen, the child born to them is granted the citizenship of India. It's based on the principle of jus sanguinis. That means person born outside India we're talking about. Through CA 2003, with effect from 3rd December 2004, Another amendment was carried out. Both the parents should be Indian citizens, or one of the parents should be Indian citizen and the other should not be an illegal migrant. The same in citizenship by birth, citizenship by descent. It was the same amendment carried out in 2003. All right. Number 3, citizenship by registration. Persons who intend to acquire the citizenship by registration give an application to the authority. The authority processes the application, verifies the details, due procedure is followed, and then grants the citizenship. Here, the very important point is the central government is the prescribed authority. The state governments cannot grant or process and grant the registration of citizenship. It is the central government which is the prescribed authority, right? And who all can apply for citizenship through registration? Who all are eligible for this process? Number 1, persons of Indian origin. We have seen who are persons of Indian origin. And ordinary persons of Indian origin are the people, a person, or either mother or father, or grandmother or grandfather, who was born in India as defined in the Government of India Act 1935, right? Persons of Indian origin ordinarily resident in India for 7 years before applying for a registration. Earlier it was 1 year. Through amendments it was changed to 7 years. If any of the person of Indian origin who wants to apply for citizenship by registration, he should have resided, legal residency is for 7 years. Next, the persons who are residing outside undivided India, so people who are staying in foreign countries, excluding countries like Pakistan and Bangladesh, they can also apply for this. A person who is married to Indian person. Earlier it was only a male. If a female marries to a male Indian citizen, that female used to get the citizenship. Afterwards it was changed to either male or female. Any person who marries a foreigner, that foreigner gets the citizenship of India if that person resides in India for 7 years and makes the application. Next, either minor child or major child of the Indian citizens, they can apply for citizenship by registration. A person of full age and capacity who or either of his parents was earlier citizens of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. That means people who were citizens for whatsoever reason, they had given up the citizenship, but now they want that citizenship, they can also apply for that. However, they should have resided or before making the application at least for 12 months. The legal residency here is 12 months for this section of people. Next, overseas citizen of India card holders, right? They should have acquired it at least for 5 years before making the application. We will see who is known as overseas citizen of India card holder in a couple of minutes. And again, even for overseas citizen of India card holder, he or she should have ordinarily resided for 12 months in India before making an application for registration. Again, there are some exceptions. The persons, these people who are applying for registration should not be illegal migrants. They should subscribe to the oath of allegiance. The oath of allegiance is a must. All people who apply for registration of citizenship, they must take an oath of allegiance. Here for this article, one more aspect is added. Any other territory which became part of India, not only what is defined in the Government of India Act 1935, all the people who were born even in the territory which was acquired by the Government of India. Alright, here for the purpose of this article, person of Indian origin is a person who was born in India, the undivided India as defined in the Government of India Act 1935, or person's mother or father, or person's grandmother or grandfather. Not only that, if the person is born not just the undivided India but also in such other territory which became part of India after 15th of August for the purpose of this section. See, for the purpose of this section, one more element is added. That is, even if they were born in a territory which was later on acquired by the Government of India, they will also be considered as persons of Indian origin for the purpose of this section. Number 4, citizenship by naturalization. Again, the prescribing authority is the central government. It may grant the certificate of naturalization to any person if these conditions are fulfilled. There are certain conditions which are to be fulfilled before granting citizenship by naturalization. What are those conditions? Let's see one by one. The first condition, the person who is going for or applying for citizenship by naturalization should not be an illegal migrant. If we observe, this is there almost everywhere. That person should not be an illegal migrant. That he is not subject or citizen of any country where citizens of India are prevented from becoming subjects. What does it mean? Let us say, for example, just for example, the United Arab Emirates, that country prevents Indians acquiring citizenship of that country. Let us say, if I go and try to acquire the citizenship of the United Arab Emirates, they reject because I am an Indian. If that kind of principle is followed by that country, we shall not grant citizenship by naturalization to the citizens of the United Arab Emirates. Alright, this is only for example. I have taken that country. What is the other condition? Before applying itself, if the person who is applying has citizenship of another country, he or she should take an undertaking that the moment their application is approved and Indian citizenship is granted, they should renounce the citizenship which they are holding. Let's say, for example, if a person is a citizen of Canada and he is applying for citizenship of India, before applying, he should undertake that the moment my application is accepted, I will renounce the citizenship of Canada. That's one more condition to be fulfilled before applying. What are the other conditions? It's a general condition where before applying, the person should have resided for 12 months in India normally. And the other condition, in fact, these two are to do with the legal residency. At least 11 years he should have or she should have resided in India out of 14 years before this 12 years. What is it? 12 months. What does it mean? Let's say a person is applying on 1st January 2020. This person should ordinarily have resided in India for 1 year, for 12 months. That is from 1st January 2019 to 1st January 2020. This person should have resided in India. Now take 14 years before 2019. That is, 1st January 2005. Since 1st January 2005 till 1st January 2019, it is 14 years. In this 14 years, this person should have resided in India at least for 11 years. Do you get the picture? If a person is applying on 1st January 2020, this person should have resided in India from 1st January 2019 to 1st January 2020. Before that, we should consider 14 years. That is from 1st January 2005 to 1st January 2019. Out of those 14 years, this person should have resided at least for 11 years. Understand? Minimum requirement is 11 years out of those 14 years and 12 months just before applying for registration. That is the minimum legal residency requirement for citizenship by naturalization. And he should be of good character. The character certificate is required. He should have the adequate knowledge of any of the languages given in the 8th schedule. As of now, we have 22 languages in the 8th schedule. The person who is applying should have known, or at least he or she should have adequate knowledge of one of the languages out of 22 languages. And he should have the intention to reside in India permanently. That's one of the important criteria. Okay, we have around 8 conditions to be fulfilled before applying for naturalization. Here, just understand, residing in India equates another aspect. Suppose if he is in the service of Government of India or any of the international organization approved by the Government of India, if he is working in those firms, either in the service of Government of India or international organizations, that is also considered for legal residency under this section. Understand? Right. The Government of India may waive all or any of the above conditions on exceptional circumstances. See, all these conditions are not required if the Government of India decides to grant naturalization to particular people. Who are those people? A person who has rendered distinguished service in the field of philosophy, science, art, literature, world peace, and human progress. Constitution uses these words. Citizenship Act 1955 uses these words: science, philosophy, art, literature, world peace, or human progress. If any person who renders exceptional service in these fields, the Government of India may waive one or all the conditions which we have discussed earlier before granting the citizenship by naturalization. Alright? Every naturalized citizen must take an oath of allegiance before applying before the Constitution of India. This is also very important. Oath of allegiance must for people who are acquiring Indian citizenship. Right. 5. Citizenship by incorporation of territory is a very simple aspect. Suppose if we acquire a territory, the government issues are either a regulation or a gazette prescribing who all shall be considered as citizens. Generally, all the people residing in the territory shall be treated as citizens of India normally. For example, we have acquired Pondicherry or Puducherry. Then the government of India passed the Citizenship Pondicherry Order 1962. It was under the Citizenship Act 1955, and it passed a few regulations related to that, stating that who shall be considered the citizens of India. Loss of citizenship. This act gives 3 ways in which a citizenship can be lost. First, renunciation. Whatsoever may be the reason, the citizen can declare renunciation. The moment they declare renunciation, even their children shall also be lost the citizenship. However, there is a catch here. The minor child who loses the citizenship because of the renunciation of his or her parents will resume the citizenship, or if that person intends to resume the citizenship, he or she can resume after attaining 18 full years. Clear? They can renounce. The moment they renounce, even the children will lose the citizenship. However, they will have the facility to resume after attaining full age and capacity. They can the citizenship can be terminated when Indian citizens voluntarily acquire other countries' citizenship. It is an automatic termination. It's nothing but emphasis of Article 9 of the Constitution. The moment the person acquires voluntarily the other country's citizenship, he or she is going to lose the citizenship of our country. Next, deprivation. The central government terminates if any person acquires citizenship by fraudulent means, or if he or she is disloyal to the Constitution, or involves in unlawful trade or communication with enemy during war. It is unlawful trade or communication with enemy during war. When we are at war, let's say we are at war with Pakistan or China, and if any person involves in illegal or unlawful trade with that country, then automatically government may terminate the citizenship. Next, after acquiring the citizenship in the next 5 years, if more than 2 years that person is imprisoned, then government terminates his or her citizenship. Out of India for 7 years continuously. If any person goes out of India for 7 years, he will lose the citizenship. The government removes or terminates citizenship of those individuals. However, there are few exceptions like students, people who are working, diplomats, and so many other exceptions are there for this class. If you really like our lectures, please press the like icon, and if you have not liked, please do press the unlike button, and we are open to the constructive criticism. You may give us your feedback on iasviewpoint@gmail.com. Please do share the information to the most needy and share this video to the most needy. Thank you.